The SEC was charged with conducting an in-depth review of the AOC, its organizational structure, the services it's provided, the various functions it played, its operations, and the role it played within the courts and the Judicial Council. Again, as we all know, the SEC completed its work and submitted their report to the Chief Justice on May 25th, 2012. They made 151 recommendations, a significant number. 4 dealt with the Judicial Council, its role and its oversight responsibility. A number dealt with the structure and organization of the AOC, and then many involved in evaluation of the individual divisions and their actions. I know that this has been said many times, but I think it's important, and again, I want to personally and publicly commend the SEC committee members for their incredible efforts, their hard work, their time, and the just significant sacrifice that they have made. As all of us know, and especially the members of Executive and Planning, as having lived with this now for far less than the SEC members had, this is a very, very valuable tool in our quest as a Judicial Council and as a Chief Justice in making improvements through this important process of self-assessment. The Judicial Council at its June meeting accepted the report and assigned the report to Executive and Planning for its further review and consideration. You all specifically directed E&P to evaluate each recommendation, to prioritize each recommendation, and to create timelines for implementation, and then bring those back to the Council for your independent consideration and, we hope, approval. In addition, the Judicial Council directed staff to post the SEC report on its public webpage. It's been accessible since, I believe, that evening to the public. We also were directed to encourage public comments for a period of 30 days, and we received a significant number of comments, very important comments. It was for a 30-day period, but as all of you know, we continued to accept comments up until today. Executive and Planning has met, as Justice Hall told us, a number of times, twice on August 9th and August 21st to review the recommendations. And I can tell you that we were able to consider all 51, and we will have, as you know, a report presented to you today with recommendations as to every single one of the SEC recommendations. E&P was assisted in this process by the chair of the SEC, Judge Walkup, by the vice chair, Judge McCabe, and by one of the committee members, Judge Ellsworth, and also by the CJA president and a Judicial Council member, Judge Rubin. They were a part of our review process and there at every moment when we discussed the recommendations. And I want to thank the Chief, again, personally, for appointing the SEC members and Judge Rubin to advise us in this regards, because their expert assistance in our review was really invaluable. I want to take just a moment, though, and talk about the process that E&P undertook. First, we received 529 comments from 513 commentators. 30 were from organizations. 84% were from judicial officers. The comments were thorough, they were across the board, and they were extremely helpful, and they were reviewed by us in our process. The comments dealt with a significant number which recommended implementation of the SEC report, that voiced support for the SEC recommendations. Various had differing opinions on implementation and the time for those to occur. A number dealt with the culture at the Judicial Council and the AOC. A number, as we have heard, dealt with access to justice and concerns in that regards. And they really were across the board with regards to the effects that the recommendations might have on the smallest court to the courts of review. When E&P met for the first time on August 9th, we initially started our process of evaluation without any staff. It was just the E&P members and the advisory members that had been appointed to assist us. And we had a number of items that we wanted to discuss in a setting with just ourselves and without staff. The first was should we have a meeting that was open or closed. We concluded that it was important for our evaluation to have a closed session so that we could talk about confidential personnel matters and that we could hear confidential information from the SEC members. And we did hear confidential information, and it was important in our evaluation. We next discussed whether or not we should even invite staff in at all. And since a number of us indicated that we couldn't write as fast as all of us talked, we thought it was important to have a staff member there to take down notes. And so we invited 3 staff members from the Secretariat office to assist us in taking down notes. Then we wanted to determine whether or not at any point during our discussion if we should invite members from AOC to answer questions. And we agreed that if there were time periods during our discussions where we needed some expert information with regards to a particular recommendation, that we would invite AO staff in. And we did. We invited Jody Patel and Judge Jar, and they provided us, again, excellent information on the recommendations and the timelines and the impacts. And then lastly, we organized our review in a way that it didn't go from recommendation number 1 to 151. We organized it in a way that it dealt with all of the organizational recommendations first, and then we went division by division. And we were able, again, to get through all 151 and have that report for you today. Now, I'm somewhat sorry for the length of my introductory and background remarks, but Executive and Planning felt it was important, very important, that you understood the process and that we explained the process that we followed. Now, I know that some have indicated that the purpose of assigning it to Executive and Planning and the purpose for our review was merely to delay the process, to maybe eventually shelve the process and the report, and to bury it someplace. But I can personally tell you that could not be further from the truth. I'm here today to report that within 2 months of the Judicial Council accepting the report, after reviewing 529 comments and hundreds of pages of the SEC report, and after meeting twice, we have a report to present to you today that deals with all 150 recommendations. We have also established a timeline for implementation and a monitoring process to oversee that the AOC follows what you as a Judicial Council direct. Now, I don't intend, and I don't know that we have enough time, to go over one by one all 150 items, but we can certainly in a moment talk about any of them that you want to, and we can discuss any of E&P's recommendations. But I do want to kind of group this into 3 important aspects of the work of our committee, and they are, first, those recommendations of the SEC which dealt with Judicial Council oversight, the Judicial Council roles and responsibilities. Second, those which deal with the restructuring of the AOC. And third, and almost most importantly, accountability and the monitoring process that we came up with. I do want to give you just a few statistics first, though. We didn't reject any of the SEC recommendations. 12 of the SEC recommendations have already been implemented. 12 were recommended for immediate implementation. 18 had already been completed as of the date of our meeting. 7 had been started to be implemented and were ongoing. 17 dealt with the organizational structure and the proposal in that regards. A total of 38 dealt with the organizational structure and classification and compensation studies. 3 dealt with referrals to the Chief Justice and concerned the assigned judges program, in which constitutionally are not within the authority of the Judicial Council to make recommendations on. 2 were assigned to the Trial Court Budget Working Group, 2 to RUPRO, and 1 to the Technology Committee. So first, those which dealt with the Judicial Council oversight and governance. E&P recommends that the 4 SEC recommendations concerning the Judicial Council oversight and governance be adopted, be approved by you, and be implemented immediately. Now, we do have one addition and one change, and if you look at attachment 1, and I think because these are so important and deal in essence with what we as a Judicial Council are all about, I do want to just read them. And these are recommendations 4.1 through 4.4 of the SEC report, and on our attachment they are 2, 3, and 4. The first one is E&P recommends that the Judicial Council take an active role in overseeing and monitoring the AOC to ensure transparency, accountability, and efficiency in the AOC's operations and practices. We recommend that for immediate implementation. E&P recommends that the Judicial Council promote the primary role and orientation of the AOC as a service provider to the Judicial Council and the courts, and we added for the benefit of the public. Next, E&P recommends that the Judicial Council, in exercising its independent and ultimate governance authority over the operations and practices of the AOC, must ensure that the AOC provide it with a comprehensive analysis, including a business case analysis, a full range of options and impacts and pros and cons before undertaking any branch-wide project or initiative. In exercising its authority over committees, rules, grants, programs, and projects, the Judicial Council must ensure that the AOC provide it with a full range of options, impacts, including fiscal, operational, and other impacts on the courts. Again, we recommend that for immediate implementation. Next, E&P recommends that the Judicial Council conduct in the SEC, it was a periodic review. We are recommending an annual review of the performance of the administrative director of the courts. The review must take into consideration input submitted by persons inside and outside the judicial branch, and that, if Judge Jar takes this job in October, will be initiated in October of 2013. We recommend that you approve and adopt each of those and accept our implementation schedule. Second, restructuring of the AOC. 17 of the SEC recommendations concern the AOC organizational structure. And even though Executive and Planning essentially agreed with each of these recommendations, we felt it was important, and we wanted to give the interim and the incoming administrative director the opportunity to review these, to consider them, and to provide the council with whatever tweaks or modifications or changes they may have felt fit within their business approach and their vision, and they will provide that to us. We directed them to present it to the Judicial Council today at this meeting in conjunction with our full report, because we considered these recommendations significant and important and ones that needed to be dealt with now and not later, and needed to be implemented on a very expedited basis. And in a moment, you will hear from Judge Jar and Jody Patel and Justice Hill with regards to those proposals. And then the third thing I want to stress today is accountability. We can come before you and recommend that you approve these recommendations. You can approve them and direct that they be implemented. And in some sense, that is all and good. But it is equally important to have a system and a process for accountability. So we are proposing the following. For those that have been indicated they have been completed, we are going to ask the AOC to report to us in writing when they were completed, how they were completed, and provide supporting documentation. For those that are in the process or are ongoing, or for those that require a report back to the Judicial Council, or for those that we have set a timeline and need to be implemented in the future, we are going to ask that they report to Executive and planning on a monthly basis, that the report be in writing, that it be provided with supporting documentation so that we can evaluate where they are in that process, how they are proceeding, and whether they are accomplishing the implementation goals that we have set. And then executive and planning will report back to the council at each of their meetings. We felt it was important not just to have a report back to you at the Judicial Council meeting, but to have executive and planning monitoring on a monthly basis so that we were up to date on where they were in that regards, and so we could monitor that aspect. So what I would like to do at this time is turn it over to Judge Jar to talk about those 17 SCC recommendations that deal with the organizational structure. And Judge Jar.
Thank you, Justice Miller, and thank you all for the opportunity to be heard this morning. As has been indicated, the report of the Strategic Evaluation Committee is global in nature as it relates to the administrative office. The presentation that Jody Patel and I will be making at this juncture will be focused on the executive office reorganization component of the SEC report, and it is hoped we will be able to demonstrate a plan for your approval that is most advantageous in the reorganization of the office. So our focus will be on the executive office with a few additions, and I will note them, which will actually address a total of no more than 21 of the 151 recommendations. First order of business, we have materials to follow along with the presentation. They include, of course, the slides that are being presented with space for taking notes. Toward the end are blow-ups of organizational charts. Don't spend much time on them right now because we intend to address them in the course of our presentation. And then at the very conclusion, there is an index. The index is to essentially our recommendations in reference to the Executive and Planning Committee's report, referencing the Executive and Planning Committee's report numbers, so that you can cross-reference, because our presentation won't follow that numerically. I learned in leadership in another organization that underwent a complete transformation that all organizations, be they private or public, require periodic self-assessment if they are to remain healthy organizations. Why is that? Each organization engages daily in problem solving. Some problems are known in advance and others come forward spontaneously. But organizations must address them and they must resolve them. And each solution to each problem has an incremental impact on the organization, necessarily. In the isolation, it's an insignificant impact, usually. But over time, in the aggregate, those incremental changes, adjustments, solutions, and movements in the organization change its course. They constitute, in the aggregate, in other words, an unintended consequence of simply conducting the operations of the organization. So, a periodic self-assessment process is a natural process with respect to every organization I submit. Here, as has been indicated already by our chief and by Justice Miller, the administrative office, as observed in the SEC report, has grown considerably over the last 10 to 14 years, in major part because it has assumed new responsibilities on delegation to the council and accordingly to that office by the legislature and the governor. That growth obviously has resulted in a number of actions and reactions, and so today we address the report and recommendation of the SEC that was commissioned by the chief as one of her first steps and supported by the council. What caught my attention as a private citizen on the sideline was that that process was announced to be a public process. It was going to be a process of self-assessment that occurred in broad daylight. When the report was received after considerable labor, it was placed out for public comment. And then, as has been mentioned, the Executive and Planning Committee assessed the public comments that came in to you. One of the central findings in the report as it relates to the executive office organizational structure is that it has, with these new responsibilities over time, grown. and become top-heavy. It is indicated in the report that that overbreadth in terms of its sheer size, that is to say the executive office, has resulted in a sort of segregation which is referred to as a silo effect. The authors of the SEC report have proposed a remedy, and the remedy is executive management restructure. And with minor modifications, we agree. I say minor, I should indicate, I don't mean to suggest trivial. I believe that they are significant and important modifications, but they are minor in the sense that I submit also they do not represent departures either from the thematic underpinnings of the SEC report or the structural recommendations that are made in the main. So the SEC proposes that we reduce the size of the executive team in order to improve the management of the administrative office, and we agree. That reduction in size will streamline decision-making, and it will also enhance and make more clear the lines of communication and authority within the administrative office, just as I have pledged as your incoming administrative director to broaden and make more clear the avenues of communication between the courts that we serve and the administrative office. The report writers for the SEC propose a clustering or grouping of the existing offices of the council based upon function. For example, a grouping together of offices with programmatic functions, the education division would be a good example, and a grouping together of the administrative functions, for example, finance. With that recommendation, we also agree. The first organizational chart, which is rather small on your screens and is reproduced accordingly in your materials, indicates the current state of affairs organizationally within the administrative office. And as you can see, over time, a number of divisions and offices have been developed. Each of them reports to a two-person executive office. Presently, the administrative director and the chief deputy director don't have denominated separate functions or areas of responsibility in the organization chart. The authors of the SEC report note that from a historical perspective, as the outside demands on the administrative office have been increased, particularly those associated with legislative activity and executive branch activity, the administrative director and the chief deputy director in the past came to emphasize more and more their external duties and responsibilities. An unintended effect of that was that internal management issues began to accumulate. The SEC accordingly has proposed a transformation in the structure of the executive office. It proposes a four-person executive office model. Immediately beneath the Judicial Council would remain the administrative director. Working with that individual would be three division chiefs: a chief of staff, a chief administrative officer, and a chief operations officer. With those recommendations, we agree. The reason for that structure, as explained in the SEC report, is that it will enable the administrative director to meet the demands from the legislature and the executive branch, because an effective management of internal operations and programs may be assumed by three high-level leadership positions. And as indicated in the report, those three positions would be viewed as co-equal, and there must be, to them, a robust delegation of duty by the administrative director. I would note that in the chain of command, it is my proposal and the proposal of our interim director that the chief of staff be designated. That's a variation from the SEC report, which identifies the chief operating officer. We believe and submit that the chief of staff is the person to whom second in command responsibilities should be addressed, and in a little bit more detail momentarily we'll reveal why. But fundamentally, the chief of staff, as identified in the SEC report, is a person who will have high-level duties of responsibility to the Judicial Council. But not just that, that person also will have a high-level liaison responsibility to the trial courts. it's important to recognize, of course, that within the AOC, there are any number of points of responsibility and contact between entities within the AOC and the trial courts. But the SEC thoughtfully indicated that at the very top of the management structure, there has to be one clear line to ensure that to the extent that problems arise relative to the efficient and effective communication between the office and the trial courts, someone within the executive office has those duties. It's for these reasons that the chief of staff, who would be charged with that liaison function, would serve as second in command in circumstances when the administrative director is unavailable, so as to ensure continuity of operations. Well, what about the existing divisions that you saw in the organization chart? What becomes of them? The existing divisions would become offices within the organizational structure, and each of them would report to one of the three divisions and division chiefs created at the recommendation of SEC. The offices would remain headed by directors, as they are now known. Their duties would be unchanged and certainly undiminished. The SEC report makes in several spots references to compensation levels. It also strongly recommends that a comprehensive classification and compensation study be conducted throughout the AOC. It is our recommendation that no compensation adjustments be made with regard to the directors until that entire study has been completed. The proposed structure, once again set forth within the report, is to create a chief of staff who would head what we have denominated the Judicial Council and Court Leadership Services Division. I believe it's referred to as the Executive Office in the SEC report. The chief of staff would be responsible for special projects and units, and as mentioned previously, would coordinate administrative office support of and to the Judicial Council, and also provide that crucial high-level liaison responsibility directly to the trial courts. The chief administrative officer, who would be responsible for what has been denominated the Judicial and Court Administrative Services Division, would have oversight of AOC business support functions that are not program specific, as I mentioned previously, for example, financial services, both to the council and the courts. Finally, the chief operating officer, who would head the Judicial and Court Operations Services Division, would have oversight of core business and service ventures and customer-oriented court programs, to use the words of the SEC report. In other words, programs such as the Family, Children, Center for Family and Children, and the courts, the Education Division, and the like. With all of these recommendations, we agree. We've set up two slides to show areas where there is either a modification or at least a potential adjustment from those recommendations contained in the SEC report regarding the executive office organization. As I mentioned previously, we recommend that the chief of staff be designated as a second in command in circumstances in which the administrative director is unavailable. The SEC report indicates that the Office of General Counsel, which is to be renamed Legal Services Office, have a direct and uninterrupted line of report to the administrative director. We propose and recommend that that direct line remain to the administrative director. However, that there be a direct report through the chief of staff in consideration of the considerable volume of opinion writing and other services provided by that office concerning not only the counsel and counsel activities, but the trial courts, and that direct line pass through the chief of staff to the new executive office. With regard to the Office of Governmental Affairs, the SEC report recommends differently that there be a direct report to the chief of staff. Here, it is our belief and submission that the OGA director and the OGA office should have a direct report relationship to the administrative director. The reason being that, as the SEC report noted, this organizational structural change is designed, among other things, to ensure that the administrative director will have the ability to focus on external demands on the council and on the office most notably, of course, those emanating from the executive and the legislative branches in Sacramento. Obviously, that means the working relationship between the administrative director and OGA will be constant and obviously, in some instances, acute. In order to enable the two to work together as nimbly as possible, it is our view that the OGA director accordingly should report to the administrative director. The editing and graphics group indicated in the SEC report to be eliminated, we propose instead to be merged into the Judicial Council Support Services Unit. It has been observed properly that to the extent that there are duplicative services performed by editing and graphics and others, those necessarily have to be ended. But that is our recommendation concerning that element. Now, here's a recommendation that doesn't appear in the SEC report. I don't believe it is one that is inconsistent with the recommendations in the SEC report, but one that is crucial in our judgment for immediate action by the council, and that is we recommend that the Office of Court Construction and Management be bifurcated, that an Office of Facilities Management reporting to the Chief Administrative Officer be created. In other words, that the maintenance and management activities within that office be separately officed. Simultaneously, that the design and construction functions of the Office of Court Construction and Management also be placed in a separate office, and that activity be more in the nature of a court operation or program, being placed under the responsibility of the Chief Operations Officer. And more on that in a moment. The Office of Emergency Response and Security, the SEC report indicates that the services and duties of that office should be reapportioned into existing AOC offices and that the office itself should be closed. It is our fervent recommendation that the office, a focal point for security issues which are central to the branch, remain open. The Executive and Planning Committee kindly proposed to defer decision relative to that issue until the December 2012 meeting to enable Jody Patel and myself to prepare a report of advocacy concerning that topic so the matter could be considered on its merits at that juncture, and we ask that you adopt the E&P recommendation in that regard at this time. Already mentioned the director compensation issue, asking that all those kinds of decisions be deferred pending completion of a classification and compensation study. We also recommend that there be a merger of traditional administrative functions into a newly established Office of Administrative Services reporting directly to the Chief Administrative Officer. Many of those things have actually occurred in terms of the kinds of reforms that Jody Patel as interim director has put into place, unknown in many quarters, but known well to the council. Extraordinary progress has been achieved during her period of stewardship since February, and in many respects, changes have occurred to the very world that the SEC members were investigating at the time they prepared their report. The last example of which is the last bullet item on this slide. In light of the realignment changes in criminal law sentencing in our state, enormous in their scope, the administrative office reorganized criminal justice services into the Criminal Justice Services Office. And it is recommended that that office, as an operations-related activity, be placed under the Chief Operating Officer. What arises from the recommendations is a proposed organizational structure. Once again, that appears toward the foot of your materials in a way that can be read a little bit better. We have placed next to it in your materials from the SEC report its proposed administrative structure for the organization of the AOC, and I would suggest that it mirrors our own proposed structure with the modifications that have been noted. What also flows from this recommendation, as it does from the SEC report, is that the position of Chief Deputy Director and the position of each of the three regional directors should be eliminated. Now, don't go too far into each of the divisions and the offices that are clustered under them, because momentarily Jody Patel will give you more of an analysis of each. First, however, I'd like to return to the issue of the Office of Court Construction and Management. to make it clear, the recommendation that we now make for your consideration is not punitive in nature. It is, in our view, the necessary first step to ensure that the recommendations of the SEC relating to the Office of Court Construction and Management can be most effectively implemented. To start at the beginning, about 10 years ago, significant legislation came into effect that had the impact of transferring responsibility for court facilities to the state, and more particularly to the Judicial Council. The court facilities that were in place for trial courts throughout California, numbering in the many hundreds, were to transfer, literally ownership, to the state of California, and the Judicial Council was to oversee that process. In addition, whereas previously it had always been county responsibility to construct new courthouses, that responsibility now was also placed in the state, and more particularly in the Judicial Council. Flowing obviously from both new construction and from transfers of old buildings, many of which suffered deferred maintenance at the hands of counties that knew they were shortly going to lose title to them, flows the new responsibility of management and maintenance. It was natural at the beginning of the project that the council essentially place in the administrative office the responsibility of beginning those processes, and that the administrative office would create one new office or division to begin to address them. Now there has been considerable maturation in those processes. Buildings are being built. Even as we have pauses in a number of the construction projects, there's obviously considerable ongoing activity on the design and construction side. On the management and maintenance side, all of those transfers have occurred. Hundreds and hundreds of buildings, many with maintenance problems that are severe, as you well know. These are two separate, severable activities. Design and construction on the one hand, maintenance and management on the other. The time has come, in our judgment, for those two activities to be severed so that they can each be performed more effectively and efficiently. Interestingly, Jody Patel and I discovered that each of us had independently reached that conclusion. The recently published Pegasus report at pages 421 through 424 reveals its conclusion that indeed the design and construction function is entirely separate from the maintenance and management function. Justice Hill, who kindly agreed to travel here today for a brief presentation, is, as you know, the chair of the Working Group on Court Construction, which you created to oversee construction activities within OCCM, and I understand that he supports this recommendation. He also has some additional recommendations alluded to on the screen relative to working group oversight in your behalf of not only construction and modification activity, but also the important maintenance activity. And Justice Hill, if I could impose on you.
Certainly. Thank you very much. And Chief, members of the Council, I fully support the recommendations as set forth to separate the two elements of the court construction and the maintenance program from one another. Our executive committee of the Court Facilities Working Group also fully supports this approach and believes that it will be extremely beneficial to both components of the program to be separate and distinct. They are separate and distinct, and it is necessary that full attention be given to each in a different setting than is currently operational. In addition to expanding the charge of the working group, and I think that, quite frankly, the court modification working group that looks at court facility modifications, those modifications like elevators and roofs and significant expenditures of funds, needs to be expanded so that that working group can review all maintenance items. The maintenance program, we believe, should have active oversight by judges and by court executive officers. There is not that form of oversight at this time. There should be, and there will be under this recommendation. Finally, I've addressed you a number of times before about decentralized maintenance, something that I believe over time many courts support. Quite frankly, although we've heard that the present system is working for many courts would also like the opportunity to handle their own maintenance. And it's our obligation to see if we can make that work. It's also our obligation not to turn it over to the courts with inadequate funding. which is what we would be doing right now. The funding for maintenance is certainly, as you've heard before, inadequate. And courts would be spending, in essence, pennies on the dollar, or be given pennies on the dollar, to maintain their dilapidating and inadequate facilities that they have been dealing with for years and years and years. We need to move down that path. We are moving down that path. We have a pilot project in place to make sure that we can get all of the bugs out for this decentralized maintenance. We need to make sure that that works. We need to make sure to get the funding. And once we do all of that, I'm sure that someone will be back from the court facilities or court modification and maintenance working group to address to you the reasons why, to the extent possible, we should decentralize maintenance. Obviously, if there are courts in the state who cannot adequately oversee these responsibilities and maintain their courts, the AOC will be there and will certainly help those courts. But for those many courts who have come to us saying they would like to be involved in this process and they would like to ultimately take over this process, we need to be there for them as well. I would just like to applaud the efforts that have just been enunciated to strengthen both of these programs. I believe that it's a timely proposal, it's a necessary reform, and it's one that I certainly urge adoption by the council. Thank you, and thank you.
Thank you, Justice Hill. In sum, as to OCCM, we request that the council direct the administrative office to bifurcate that office into the two that have been proposed, that we in the executive office work closely with Lee Willoughby, manager of OCCM, to ensure that an implementation plan for that separation can be devised which is not disruptive of the important daily functions both sides of that house conduct, and that we bring that proposed plan back to you and your council at the December meeting for its consideration and, it is hoped, approval, so that the process can be begun, which in turn, in my view, will facilitate addressing not only the recommendations of SEC, but now the Pegasus recommendations. And with Justice Hill's permission, I would certainly ask that you, at this juncture, consider expanding the charge of the working group on modification to include oversight of maintenance and management. Now, as I promised previously, we're going to get into a little bit more detail, drill down, if you will, regarding the three proposed new divisions: operations services, administrative services, and then the leadership services division, which would be headed by the chief of staff. I'm going to turn the chair over to Jody Patel, given that the screen controls are here.
Yeah, that's okay. I'll just scoot over. You can stay. That's all right. Okay. Thank you, Judge Jar. Good morning, Chief, members of the council. As Judge Jar just indicated, I will provide a little bit more specificity with regard to the areas of responsibility for the Chief of Staff, Chief Admin Officer, and Chief Operating Officer. For the Chief of Staff, this individual will lead the Judicial Council and Court Services, Court Leadership Services Division. This individual will provide and support the Judicial Council, the trial court presiding judges, and court executive officers advisory committees, the trial court liaison office, formerly known as the regional office, and special projects office, formerly known as the re-engineering unit, which was housed in the Northern Central Regional Office. The org chart in front of you denotes that the Chief of Staff's areas of responsibilities. You will note, as Judge Jar indicated, the Legal Services Office would be a direct report to the Chief of Staff, with a line of reporting also directly to the Administrative Director. And the red on these org charts represents the change that Judge Jar indicated in terms of the slight modifications that we've made to the SEC recommendations. The Chief Administrative Officer leads the Judicial Courts Administrative Services Division. This area will house all of your traditional administrative services for the Judicial Council, AOC, and the Judicial Branch. Under the Chief Administrative Officer, we will have the Fiscal Services Office, currently known as the Finance Division, our HR, Human Resources Services Office, which on April the 1st was temporarily merged with our Trial Court Administrative Services Division as a result of some personnel changes. We recommend, consistent with the SEC, that be once again bifurcated from the Trial Court Administrative Services Office and be a standalone Human Resources Services Office. Also under the CAO is the Trial Court Administrative Services Office. All of your Phoenix financial and HR activities reside under that office. And our IT services would also be under the CAO. The two modifications from the SEC recommendations are the last two boxes that you see in front of you. The Office of Administrative Services, which would be a new office that would house normal administrative services that are provided not just to the council and AOC, but to other branch entities, such as reception staff here in this building, mailroom operations, copy services, as well as records. And we felt that it was important for all of those activities, which currently reside under our education division, to be a standalone office under the CAO. And lastly, as both Judge Jar and Justice Hill, you've just heard, the Office of Facilities Management that would include maintenance as well as asset management would reside under the CAO. The Chief Operating Officer leads the Judicial and Court Operations Services Division. This will house all of your normal programs and activities that support court programs, operations, all of the collaborative services with regard to our trial courts and appellate courts, as well as other court services. And once again, you have in front of you the organization chart for the Chief Operating Officer, or COO for short. The COO would be responsible for Court Operations Special Services Office, currently known as the Court Programs and Services Division, the Center for Families and Children, our Education Division and Seizure. The last three boxes in red are the slight modifications from what the SEC recommended. First, we would have our Office of Judicial Branch Capital Programs, which once again is something that Judge Jar and Justice Hill just discussed with regard to our court construction program and activities. We also have our Criminal Justice Services Office, and as Judge Jar indicated, this is an office, historically, the activities of this office were housed with our Bay Area Northern Central Regional Office, and was responsible for items such as reentry court, implementation of the legislatively mandated work of SB 677. However, with the criminal realignment legislation that went into effect, and which was basically the catalyst for us merging the realignment activities with that office, it made sense for us to create a standalone office called Criminal Justice Services Office, in light and recognition of the fact that criminal operations and the criminal filings in all of our trial courts are the highest volume areas in each of the trial courts. And so, and we believe that the Criminal Justice Services Office will continue to provide support to our courts and to the legislature and other entities on an ongoing basis, which made sense to then make it its own office. And lastly, as Judge Jar mentioned, the Office of Security, we request that you allow us an opportunity to evaluate the functions and activities of our Office of Security and come back to you in December with a recommendation with regard to what their core functions would be along with their staffing needs. So with that, I'll turn it back over to Judge Jar and then Justice Miller.
Well, thank you all once again for the opportunity to be heard. I don't think that, as I say, it's any surprise that so many changes have already occurred since the members of the SEC began authorship of their report, largely due to the initiative of Jodi Patel as interim director. She chose not to simply act as a placeholder, far from it. The accomplishments that she has definitely credited our agency are really quite remarkable. She and Kurt Soderlund, who's worked hand in hand with her, have made huge progress and have also dealt with some of the most unpleasant aspects of the work. As you know, during her tenure, well more than 200 staff members have left the agency as a consequence of the dire budget circumstances that have occurred. So this is a time of great challenge. And I submit to you, accordingly, it's a time of great opportunity, particularly given the leadership that the Chief and the Council have shown in this enterprise. We thank the Executive and Planning Committee for enabling us to make this presentation this morning, and we request now that with respect to the Executive Office reorganizational components of the SEC report, that its recommendations be adopted with the modifications that we have proposed. We also request, with respect to implementation, that you order the establishment of a new executive office, operational by October 1 of this year, with concurrent action to begin implementation of divisional reorganization, that you direct our interim director to begin that process pending my first day as an employee on October the 8th, and we ask that you direct our office to report back to you at your October and then again your December meetings regarding progress toward that implementation. Justice Miller.
Thank you, Judge Jar. And just in closing, again, I want to thank the Chief for commissioning the SEC report. I want to thank, again, the 3 SEC members who are now Judicial Council members for your past, and I stress past, hard work and the difficult tasks that you undertook and completed so valiantly. But now the recommendations are ours. They now are the Judicial Council's, and we own them. And together, all of us as a Judicial Council must assume the important responsibility to implement and monitor the recommendations which I hope you approve today. But even with your approval, unfortunately, our work won't magically end today. As we've heard from the public comments both yesterday and today, we have to continually strive to improve, to continually strive to enhance access to justice, to serve the courts and the public, and I think importantly to continue, which the Chief has started, to look deeply inward and perform self-assessment. And again, as we heard today, in this process we will certainly have differing opinions, we will certainly have disagreements, we will certainly have strong discussions as to which path we should travel. But I believe that as a branch, we must now move forward and we must turn the corner together.